change name. What is the context? So the High Court of Delhi and Allahabad recently ruled that right to change one's name or surname comes under the ambit of right to life under Article 21. Now, Article 21 basically relates to your right to life and personal liberty. Now, why does right to change one's name comes under the ambit of Article 19, Clause 1, Subclause A and Article 21? Because when it comes to a name of an individual, it is very intrinsic to a particular individual. And the name is also very personal or very unique expression of one's identity. That is why the right to change names comes under the ambit of Article 21 and Article 19, Clause 1, Subclause A. Because it deals with freedom of speech and expression. And expression of your name, the way you want to, also falls under the ambit of right to freedom of speech and expression. That is why right to change name comes under the ambit of this Article 19 as well. Now let's look into the background of the case. Now in Sadanand and others versus CBSE and others case, a petition was filed by two brothers in Delhi High Court requesting to set aside a letter issued by CBSE which refused to change their father's last name from Mochi to Nayak in their 10th and 12th board certificates. And when it comes to MD Sameer Rao versus State of UP, what is the background of the case? Here a petition was filed in Allahabad High Court against an order passed by Regional Secretary, Madhyamik Shiksha Parishad Regional Office in 2020 rejecting Shahnawaz's application to change his name to MD Sameer Rao in his high school and intermediate certificates. Now the reason for name change when it comes to this particular case was Sadanand and others versus CBSE was their father changed his last name owing to caste atrocities and published it in the newspaper and Gazette of India as was required. His surname was changed across various public documents, Aadhaar, PAN, voter ID. When it comes to the MD Sameer Rao versus State of UP case, the petitioner was seeking name change for a higher sense of self-worth. Now, why CBSE refused to change the name? When it comes to Sadanand and other case, CBSE refused to update the brother's certificate with the father's new surname, stating that a change in name would subsequently entail a change in their caste, which could be misused, and that changing father's name beyond school records is not permissible. What was the cause of refusal in MD Sameer Rao case? The board, Madhyamik Shiksha Board, refused to update the name of his school certificate, stating that the name change is not an absolute right and is subject to restriction imposed by law. In this regard, we need to understand what are absolute right and what are qualified rights. When it comes to absolute right, these are such right against which the government cannot impose any sort of restriction. One of the absolute fundamental right is Article 17, against which the government cannot impose any restriction. But majority of the rights are qualified in nature. What do I mean by qualified fundamental rights? That against these fundamental rights, the government can impose certain reasonable restrictions. But whether those restrictions are reasonable or not, that is to be examined by the courts. But when it comes to qualified fundamental rights, they are the ones against which the government can impose certain limitations. Okay. So, in this case, the board pointed out that when it comes to right to change name, it is not an absolute right. It is subjected to restriction imposed by law. Now, what was the court verdict? Now, Delhi High Court held that CBSE denial was totally unjustified. It noted that the petitioner have very right to have an identity which gives them an honorable and respectable identity in the society. It allowed the name change while holding that right to identity is an intrinsic part of right to life under Article 21. As we discussed right now, that when it comes to a name of an individual, it is very intrinsic to that particular individual. That is why it falls under the ambit of Article 21. Right to life includes within its ambit right to live with dignity, which includes not to be tied down by any casteism faced by a person due to the caste to which he or she belongs. Thus, it allowed name change to avoid caste atrocities. And when it comes to the other case, the Allahabad High Court held that by rejecting the request of name change, the authorities have violated the fundamental rights of the petitioner guaranteed under Article 19, Clause 1, Subclause A, Article 21, Article 14 of the Constitution. What are these rights? Article 14 basically talks about equality before law. So it implies that no particular section of the Indian society would be provided with any sort of special privileges, and everybody, whether you are rich, poor, everybody is equal in the eyes of the law. No one is above law. Okay. So if you commit a mistake, if you commit any sort of crime, then you would be subjected to the ordinary law of the land administered by ordinary courts. This is what equality before law implies. Article 19, Clause 1, Subclause A refers to right of freedom of speech and expression. And we discussed right now that name is basically an expression of individual's unique identity. That is why it falls under the ambit of Article 19 and Article 21, which relates to protection of life and personal liberty. Allahabad High Court said that concurrence of all identity related documents is essential, and separate names in identity documents can lead to confusion in identity, and possibility of mischief is also there. It allowed Srinivas to become MD Samir Rao while observing that the right to keep a name of choice or change the name according to personal preferences comes under the ambit of right to life guaranteed under Article 21. Now, in this slide, we also have similar judgments in this regard, like Kashish Gupta versus CBSE 2020 judgment. In this, Kerala High Court allowed the name change, which was denied by CBSE, and held that to have a name and to express the same in manner a person wishes is a part of Article 19, Clause 1, Subclause A, as well as Article 21. The state or instrumentalities cannot stand in way of the use of any name preferred by an individual or for any change of name into one of his choices except to the extent prescribed under Article 19, Clause 2 of the Indian Constitution. This talks about the restrictions on freedom of speech and expression, which basically talk about that Article 19, Clause 2 imposes reasonable restriction on the exercise of rights conferred under Article 19, Clause 1 in the interest of sovereignty and integrity of India, security of state, friendly relation with foreign states, etc. In Ryan Chawla versus University of Delhi 2020 judgment, the Delhi High Court ruled that name change is an intrinsic element of identity. Name is an intrinsic element of identity and included the right to change name under Article 19, Clause 1, Subclause A, along with Article 21. So, more or less, all these judgments were pointing out the same thing, that the right to change name falls under the ambit of Article 19, Clause 1, Subclause A and Article 21. And this last judgment, Coriel and Oric versus Netherlands 1994, in this case, the Human Rights Committee said that name is an indispensable component of a person's identity and falls within the realm of right to privacy, which is an intrinsic right which is provided to us under Article 21 after the K.S. Puttaswamy judgment. Now, restrictions on right to change name. Allahabad High Court clarified that although right to change name is a fundamental right, it is not absolute and subject to reasonable restriction, but these restrictions needs to be fair, just and reasonable. Now, the Allahabad High Court also highlighted that principle of proportionality is an essential facet of guarantee against arbitrary state action, as it ensures the encroachment of rights is not disproportionate to the purpose of law. Now, we need to understand what is this principle of proportionality, which was given by the Supreme Court in K.S. Puttaswamy judgment. Now, if a particular action of a state is interfering with right to privacy or other fundamental rights, the court would be looking into certain conditions, which it has termed as principle of proportionality. What are the conditions? The court would be looking into this aspect, that whether the action of the government, which is interfering with the fundamental right or right to privacy, is it sanctioned by law or not? So, such a state action needs to be sanctioned by law. Then it would be looking into this aspect, that whether that state action is necessary in a democratic setup to realize a legitimate aim. Okay, so that state action needs to be necessary in order to realize a legitimate aim. Third aspect which the court would be looking into is the nature and extent of such state interference should be in proportion to the goal or the aim it intends to achieve. Okay. So, there needs to be a proportionality between the nature and the extent of state interference and the purpose of that state intervention. Okay, and there needs to be procedural safeguards against the abuse of the state action. This was also something, this principle was used by the Supreme Court in Aadhaar judgment as well, okay, wherein it applied this principle of proportionality, and in that very judgment, the Supreme Court stated that the use of Aadhaar by private companies is not allowed, it is not mandatory, okay, it is voluntary, it is up to the individual if they want to provide the Aadhaar, but it could not be made that a person has to mandatorily provide the Aadhaar details for getting a private service, okay, but the providing of Aadhaar details is mandatory for getting the welfare services from the government according to Section 7 of Aadhaar Act. And it also gave importance to the role of human dignity in determining the proportionality of a law, putting restriction on a constitutional right. The last thing that we need to make note of in this very article is, what is the process to change the name? The process of changing one's name in India involves the following step. First, you need to determine the reason for the name change. Then you need to draft an affidavit, which would be including the applicant's current name, desired new name, the reason for name change and relevant details, etc. Then you need to publish a notification in Gazette of India. The notification should be in the prescribed format and should be published at least in 2 local newspapers. Then apply for a name change deed. Is a legal document that confirms the name change and includes the details of old and new names. It should be on a stamp paper of the appropriate value as per the state in which the applicant resides, and it should contain signatures of 2 witnesses. Lastly, submitting the name change deed to various authorities. The name change deed should be submitted to authorities like Passport Office, Bank, other government agencies, along with the copies of gazetted notification and affidavit for updating the records.